Today I'm going to explain to you when and how you can change employment without affecting your ongoing green card application. You see, there's a specific provision called the American Competitiveness in the 21st Century Act of 2000. That law, for the first time, allowed foreign nationals in the year 2000 to be able to port their green card application under certain circumstances to a new employer and continue on with their green card application. So let's take a look at those requirements. The first requirement is that the I-140 petition has been approved. That's the first requirement. So if you have a PERM application, you're done with the PERM application, and your I-140 was filed and approved, right? Then you have met the first requirement. Or if you are the recipient of a national interest waiver petition, I-140 in the second preference category, or if you have received approved I-140 because you're a beneficiary of an EB1 petition under the Alien of Extraordinary Abilities, or the outstanding professors or researchers, or multinational executives, all those three subcategories are in the first preference category. Anyways, whether it is first or second or third preference category, whether there was a PERM or there was no PERM, the first requirement is that your I-140 is approved. This means that if you have a PERM application that you have not gotten certified, you cannot take advantage of the portability rule. And if you change your employer, you must restart the PERM application again. The same thing if you have a PERM application that's been approved, but the I-140 has not been filed, or has been filed but not approved, then changing to another employer may cause the departing employer, the employer that you're leaving, to withdraw your I-140 petition. And under those circumstances, you cannot take advantage of that rule. So the first requirement is I-140 must be approved. The second requirement is that 180 days have passed since the filing of the form I-485. 180 days have elapsed since the filing of the form I-485. If you have not filed form I-485, you can change employers and you'll retain your priority date in the subsequent employer. But until you file that I-485 form and 180 days later, right, that's the second requirement, you cannot port your green card application. For those individuals from India and China and that they don't have a visa available immediately and they have an I-140 approved, they can change employers. They'll have to start a new PERM. They have to start a new PERM and a second I-140, and the second I-140 will recapture the date of the first I-140, so your priority date is preserved. By the way, there is no such thing as transferring your I-140, which I hear from some of my foreign national clients. You cannot transfer your I-140. You can recapture the date in a subsequent I-140 petition. So the second requirement is 180 days have elapsed since the filing of the form I-485. The final requirement, the third requirement, is that the new position is in the same or similar occupational classification which gave rise to the I-140 petition. The new occupation in the new employer is same or similar to the one that gave rise to the I-140. So if the I-140 was filed because of a PERM application, okay, then the PERM application job duties and the new job duties at the new employer must be same or similar, okay? Must be same or similar. But if there was no PERM, as an example, EB1 or National Interest Waiver EB2, there is no PERM application for those petitions, but there is an I-140. The position which gave rise to the I-140 petition must be same or similar. So the question of same or similar has some rules. So let's take a look at those rules. In order for a job to be in the same or similar occupational classification, the USCIS looks at several factors. The title of the positions is not determinative. For instance, if the position that gave rise to the I-140 or the PERM was for a software engineer, but the new employer calls it consultant, the title doesn't really matter. What matters is the job duties. the job duties of the position that gave rise to the PERM or I-140 petition, and the new job duties. And what we do in our firm, we conduct what I call, this is my own language, line by line analysis. So I list the duties of the position that gave rise to the I-140 or the PERM application, and then I list the duties of the new duties of the new employment. Then I do a similarity analysis to show that to the U.S. CIS officer that at least 50% of the duties are similar. Another factor that they look at in determining whether or not the jobs are similar or the same is the minimum requirements of the two positions. If one position requires a master's degree, but the I-140 position required a bachelor's degree, then they would take that into consideration as well. That in itself should not cause a denial, but if there are more dissimilarities in the job duties and the minimum requirements, then the USCIS may actually deny the application. Another factor they look at is the occupational code, right? So the occupational code of the new position and the occupational code of the position that gave rise to the I-140 petition or the PERM application. The occupational code is something that the Department of Labor has for each position. So in the occupational handbook of the USCIS, there are all these codes that are listed, and they look at these codes to determine whether or not the jobs are similar. In order to file a job portability application, which I highly advise clients to do, I hear some lawyers that say, by the way, well, there's no RFE, you might as well just go ahead and just ride it out with the new employer, hoping for your I-485 to be approved. That is wrong, folks. That is wrong. Why? Because later in the future, you're going to file a citizenship application. And in the citizenship application, you're going to have to list all your employment. And if the USCIS officer saw that your application was approved for employer A, at the same time you were working for employer B without the portability application that was filed, that can cause reopening of your green card application and re-examination whether or not you have moved to a same or similar job. So I don't advise individuals to write it out or to ignore the portability requirement by hoping that the I-485 will be approved without submitting a proper application. I would like to also add that the portability application has a form, a specific form called Form I-485J that must be completed and signed by the new employer attesting and confirming the availability of a job offer in the same or similar occupational classification. One note that I might add to at the end of this video is that a person can port his or her green card application to a company that they own. In other words, you can start your own business and then have a new company that you created to port your application for a green card, and that you would actually be signing the Form I-485J on behalf of the employer and on behalf of the employee as well, and that is yourself. And that has been confirmed by the USCIS in a memo that they issued, that portability to one's own company is allowable. I've done this successfully in the past, and I'll be happy to help you to do that. Now, in order to port your green card application to your own company, there has to be certain corporate documentation to confirm that the new job that you're going to be occupying in your own company is same or similar. So with that, I conclude my video. I hope you found it useful. And if you did, please don't forget to share, like, and also subscribe to my channel and hit the bell button. I hope that to see you soon, and take it easy.